The President, please be seated. The President, the court is now in session. This morning when we adjourned, it was when the judge asked questions through the co-counsel for the accused. I would like now to give the floor to the judges of the bench.
Mr. Concrete Theory, you mentioned that that there was violation of international customary laws. How would you explain, or where would you see this violation of the international customary law?
Thank you, John, for your question. Regarding the application of the international customary law, is contradictory to the civil law system practiced in Cambodia. The international customary law and the case law used shall not be inconsistent with the practice used in Cambodia. Even relying on the interpretation of the common law, that is the case law on the international customary law, they shall compare and see the distinction in the commission of an offense, and that the law shall be formed for the court which use a similar system. However, here at the ECC, it's a mixture of the application of those laws, that is the combination of common law and civil law systems. And therefore, the application of the international customary law, which is a violation, is that they do not examine the existence of the offense. If the crime committed in Yugoslavia or Rwanda its existence cannot be comparable to the crimes committed during the Democratic Cambodia, unless a similarity exists, then the law cannot be applied. That is in regards to the violations of the international customary law. Decisions made in the judges cannot always be applicable to the decisions made in this court because of the definitions on those offenses. Thank you.
Mr. Soviet, may I ask you, suppose we are to hold that the appellant is not one of the senior leaders of Democratic Cambodia, but he is one of those most responsible for crimes committed during 75 and 79. What would you say, or how would you explain that, or what would be your defense that he was not one of those most responsible? I ask you this question because when you are talking about those who are most responsible, there can be degrees of that responsibility. So whether the conduct of others outweighed your responsibility, could you elucidate on that point, please?
Thank you, Your Honor, for your question. In 1975, the period that the Your Honor asked, I'd like to reiterate that in 1975, Cambodia Ellis Dutch was at M13 in Om Lang in Tpo District, Kampong Speu Province. He did not participate in the evacuation of people nor the killing of people. In the judgment, as well as in the indictment, it states that the people who killed, those who killed the people were the military officials. And Dutch at that time was a policeman in Kampong Speu. He did not involve in the killings of people in 1975. Thank you, Your Honor.
May I ask you, Mr. Kasayut, that when the appellant gave evidence before the trial chamber, he stated there were more than the number that already indicated who died in S21, and I am responsible for the crimes without denial. I was the person alone who was in charge of the crimes, and I still maintain that position. Is there any explanation that you could, at this stage, deduce to why you made that admission before the trial chamber?
សូមគោរពលោកចៅក្រម
Thank you, Your Honor. What I raised in my oral submission this morning that Dutch is a perpetrator because those prison chiefs of 195 prisons are considered perpetrators and fall outside the jurisdiction of the ECCC. Therefore, staff and Dutch of S21 shall be perpetrators and fall outside the jurisdiction of the ECCC. Thank you. The President, you may now proceed. Judge Sam Sarivut. I have a question to the co-lawyers of the accused. In Part B of the paragraph 109 of the document F14, and during the hearing this morning, you request the Supreme Court chamber to consider that the detention of Cambodia Ellis Dutch is a form of protection for a potential witness in identifying senior leaders and those who were most responsible for crimes committed at S21. The question is, can you clarify if there is any legal basis for your argument? Thank you, Your Honor, for your question. I would like to respond to your question. Our submission requests that the detention shall be considered as a form of protection for a potential witness because Dutch was arrested and detained illegally by the government. And secondly, he also provided testimony in regards to the S21 crimes and also to overcome the interview by Netaya with Pol Pot, that it was formed by the Pol Pot, by the Vietnamese group. But in fact, Dutch said S21 was established during the Khmer Rouge regime with him as the chief of Son Bal, and Nun Chi and Son Sen were his superiors. Also, if we consider the legality of evidence, we can also review the document stated by my colleague this morning, that is a document dated 30 March 76, which lists a number of people who could smash the people inside and outside the rank. There were those who were within the standing committee of the party, that is, for the smashing in the autonomous zones and around the central office, and for the second line, that is for the military, the central military with Son Sen as the general staff to conduct those operations. So Son Sen was actually the one who directly supervised S-21, and once he was transferred to the border to counterattack the Vietnamese, Nun Chia told Dutch that he was the chief of S-21, because Dutch sometimes he protested to the order to kill some people at S-21. That's why Nun Chia made a declaration that he was the chief of S-21 and not Kang Kech Yew alias Dutch. And this is the evidence attached to the legality that Dutch could be a potential witness. And the second point is that Kang Kech Yew alias Dutch always cooperates with the court. And actually, the court put some questions regarding the crimes committed at S-21 as well as the hierarchy of the S-21, which were fully cooperated and responded by my client. That is the reason the previous detention shall be considered a form of protection for the witness. Thank you, Your Honor.
I have one question to the Defense Counsel. In your argument in this morning session, you emphasized that the accused was not a senior leader, and he was instead in a position to receive orders from his superiors. I would like to ask you your observation on Article 29 of the ECCC law. In the second sentence of Article 29 of the ECCC law, it says the position or rank of any suspect shall not relieve such person of criminal responsibility or mitigate punishment. In the fourth sentence of the same provision, it says the fact that a suspect acted pursuant to an order of the government of Democratic Cambodia or of a superior shall not relieve the suspect of individual criminal responsibility. I would like to ask the Defense Counsel to clarify how your present position could reconcile with these provisions. Thank you. សូមគោរពលោកចៅក្រម
Thank you, Your Honor. I'd like to respond that the word suspect, according to Article 2 of the ECCC law, which defines that the senior leaders of Democratic Cambodia and those who were most responsible for the crimes, they are considered as suspects. That is point number one, Your Honor. The persons who committed the offenses
នោះឲ្យរួចផុតពីបទល្មើសជំរាបថាច្បាប់នេះគេចែងចងក្រងជាទូទៅ
is that in this law the law defines the suspects for the crimes they commit. If a person commits a crime in another country, the person shall be arrested and prosecuted. However, the ECC law is specific and it restricts the types of people who commit the crimes, that is, the senior leaders and those who were most responsible. So the rest are considered perpetrators. And the perpetrators, co-perpetrators, accomplices, for example, they are outside the jurisdiction of the ECCC. And as I stated previously, 195 other prison chiefs were considered perpetrators, and Dutch subordinates are also considered perpetrators, and Dutch himself receives the orders from Son Sen and Noon Chea, so he shall also be considered perpetrator and fault outside the jurisdiction. Congratulatory, I would like to add to the comments made by my colleague. In Article 29 as your judges and judge quoted regarding the rank or the position of the person, I think it is barred by the domestic law and the international customary law. However, your honors also review Article 1 of the agreement and Article 1 and 2 of the ECC law that this court shall only prosecute those who were senior leaders and most responsible for the crimes committed. This means that if he is found to be amongst these two groups and that he acts without duress, then he shall be prosecuted, but the evidence reveals that he is not within the two groups. And according to the general principle of legality, or the defense, the necessity defense, then he shall not be prosecuted. Here we are not talking about the subject matter jurisdiction. We are referring to the personal jurisdiction. If my client does not fall under the personal jurisdiction, then there is no need to examine other jurisdictions. Thank you. President, I would like now to give the floor to the co-prosecutors to respond to the oral statement made by the defense team. Good afternoon, Your Honors. Good afternoon, everyone. After hearing the oral submissions by the defense team for Kang Kech alias Dutch and the statement made by the accused, we would like to make the following response. Today, the Supreme Court Chamber of the Extraordinary Chambers in the Courts of Cambodia opens a public hearing on the appeals by the parties. From the 26th July 2010, the date in which the trial chamber pronounced its judgment, the defense team and the civil party lawyers appealed against the judgment of the trial chamber. The co-prosecutors filed our brief on the 13th October 2010, and the defense team filed their brief on the 18th November 2010. On the 20th of December 2010, the co-prosecutors filed our response to the appeal briefed by the defense team for Dutch, and on 14th January 2011, Dutch response team also replied to the response by the co-prosecutors dated 20 December 2010. Lastly, the defense team also submitted new evidence on the 25th February 2011, and the co-prosecutors would like to respond to the submission and the briefs to the response of the co-prosecutor dated 20 December 2010 with the following arguments. On the issue of personal jurisdiction over Dutch, the defense team in their written submission, referring to Article 209 of the Code of Criminal Procedure and the ECCC law, that Dutch falls outside the jurisdiction and Dutch shall be released, and that the previous detention shall be considered as a form of protection for a potential witness to identify the senior leaders and those who were most responsible for the crimes committed within the framework of S21. The arguments raised by the defense team, we would like to respond that in regards to Article 290 of the Code of Criminal Procedure and the ECC law, that Dutch falls outside the jurisdiction is contradictory to Article 1 of the ECCC law, which is a special law for the enforcement and implementation in this ECCC. In addition, Dutch cannot be considered a potential witness in case 001, as Dutch recognized his role and responsibility, in particular the recognition of the crimes committed at S21 as chief of the Santabal office of S21. Therefore, Dutch is the most responsible person for the crimes committed within the framework of S21. Which is a special center within the hierarchy and structure of all the security centers within the democratic Cambodia. For the determination of the responsibility of Dutch within the framework of S21, the co-investigating judges categorized the dossier into separate files, and as a result, Dutch was sentenced by the trial chamber to a single sentence of 35 years of imprisonment. And in case 002, Dutch can be a potential witness to identify those who were the senior leaders involved in the crimes committed within the framework of S21. And Dutch was not charged in case 002 by the co-investigating judges. During the initial stage of the hearing of the trial chamber, the defense team for lawyer only raised the issue of preliminary objection on the statute of limitation of the 1956 Penal Code on genocide and on murder and torture, which was stated in Article 3 of the ECCC law, which at that time these two offenses were rejected by the co-investigating judges to include in the indictment or the closing order, and which we appealed. And finally, the pre-trial chamber agreed with the appeal of the co-prosecutors to include these two offenses in the indictment. Therefore, the submission by the defense on the personal jurisdiction in their response to the appeal of the trial chamber cannot be accepted because it is contradictory to the spirit of Rule 89 of the internal rules, which states that parties need to raise their preliminary objection during the initial hearing, otherwise they cannot be accepted. In addition, the defense team did not appeal the sentence or the conviction, as the trial chamber sentenced him to 35 years imprisonment, and the defense team raised the issue of error on the determination of personal jurisdiction of Dutch. And on this particular personal jurisdictional issue, the trial chamber decided appropriately, as it had formed the view that Dutch fell within the jurisdiction of the ECCC as a person who is most responsible for the crimes committed within the framework of S21, committed from 17 April 1975 to 6 January 1979. In addition, Dutch himself frequently acknowledged his responsibility for crimes committed within the framework of S21 as chief of the center even during the investigative stage. And on the last day of the hearing, after a 9-month period from the 30th of March 2009 to the 23rd of November 2009, which was the last day of the presentation on the oral argument. For the oral argument, final oral arguments, the defense team raised the issue of personal jurisdiction over him, and that he did not fall under the jurisdiction, he shall be acquitted. Dutch himself also stated that the trial chamber shall release him. In contrary, the international co-lawyer stated that he only seek the mitigating or lenient sentence for Dutch. Dutch defense team raised that the objection raised by Judge Lavange in the conviction, which shall not be more than 30 years, indicates that the trial chamber cannot find sufficient vote on the determination of jurisdiction over Dutch. This means, as we understand, the arguments raised are not correct, as the trial chamber found that Dutch falls within the jurisdiction of the ECCC as a person who is most responsible for the crimes committed from 17 April 1975 to 6 January 1979 within the framework of S21. However, in fact, Judge Lavange and Judge Cartwright objected to the application of the 1956 Penal Code, which is stated in Article 3 of the ECC law on murder and torture, as it violates the principle of retroactivity as raised in the preliminary objection raised by Dutch defense team during the hearing. We also would like to submit that the interpretation of the law stated in Article 3 of the ECC law, pursuant to Article 12 and Article 30 of the agreement, this tribunal shall apply the domestic Cambodian law. In case there is a lacuna, then international law shall supplement. And the ECC law was adopted by the Cambodian National Assembly with the use of the civil law system in Cambodia, and judges saw not interpret differently. The rest by the defense team that Deutsch was at the lowest level of the Communist Party's hierarchy within the Democratic Cambodia government, as relying on the document of Mr. Greg Atchison that Dutch position is similar to that of a regiment commander, and he is not of any higher position or a minister of any ministry. In contradiction, Dutch only had a role similar to that of a commander of a regiment. And how many people under in one regiment is uncertain. The actual number of soldiers within the regiment is always unclear. However, based on the testimony of those before the co-investigation judges, that the staff of I-21 comprised of those from Division 703 of NAP, and there were about 300 of them, and from M13 about 10, and some forces were led by Comrade Sok. In addition, according to the document regarding the forces at I-21, there were a total of 2,327 workforces